Today, the U.S. Supreme Court is addressing a highly significant issue: the hearing on President Trump's executive order aimed at ending birthright citizenship. This policy, established by the 14th Amendment in 1868, has been fundamental to American immigration law. As the nation watches closely, the implications of this debate are anticipated to resonate deeply across legal and social landscapes. President Trump, on his first day back in office on January 20th, 2025, signed an executive order targeting birthright citizenship. This directive instructs federal agencies to restrict automatic citizenship for children born in the U.S. unless at least one parent holds U.S. citizenship or is a lawful permanent resident. This controversial move has sparked intense debate across the country, as it challenges long-standing interpretations of the 14th Amendment and could significantly impact the nation's immigration framework. In response to President Trump's executive order on birthright citizenship, 3 federal judges from Washington state, Massachusetts, and Maryland have intervened with nationwide injunctions. They argue that the directive likely contravenes the 14th Amendment of the U.S. Constitution, which affirms citizenship for all persons born or naturalized in the United States. These rulings mark a critical judicial pushback against the administration's attempt to alter the established understanding of citizenship rights. Today, the Supreme Court is set to deliberate on a pivotal procedural matter rather than directly reviewing the constitutionality of President Trump's policies. The focus is on assessing whether lower court judges possess the authority to issue nationwide injunctions that halt presidential directives amid ongoing legal disputes. This inquiry could significantly impact the judiciary's role in checking executive actions, especially as similar cases continue to surface. The Supreme Court's decision could lead to a significant shift in how birthright citizenship is applied across the United States. If the court supports the Trump administration's stance, only 22 states that contested the order would remain unaffected, while 28 states might have to enforce the policy. This could result in a scenario where the citizenship status of newborns differs depending on the state in which they are born, raising complex legal and social questions about uniformity of rights across the nation. Legal experts, however, largely anticipate that Trump's proposal will be declared invalid. This expectation stems from the 1898 Supreme Court decision in United States versus Wong Kim, Arkansas. The ruling established a clear precedent that children born on U.S. soil to non-citizen parents are entitled to citizenship. This historical decision is likely to play a pivotal role in any legal challenge against the current administration's efforts, reinforcing the notion of birthright citizenship as a firmly rooted principle in American jurisprudence. Numerous state attorneys general have expressed concern over the implications of Trump's order, which could potentially revoke citizenship from over 150,000 children born annually in the United States to undocumented immigrants or individuals with temporary legal status, such as those on student visas. They argue that this move could have far-reaching consequences for families and communities across the nation. This situation highlights the ongoing debate about immigration and citizenship policies, and how they intersect with long-standing legal interpretations and constitutional rights. As discussions continue, the outcome of this order remains to be seen, warranting close attention to future legal proceedings. The Supreme Court's decision to hear the Trump administration's appeal signifies a pivotal moment in the ongoing discourse surrounding presidential authority and constitutional boundaries. This appeal marks the first instance under the current administration where oral arguments will be conducted, underscoring the importance of the case. As the court deliberates, the ramifications on executive power and constitutional interpretation will be closely scrutinized, adding another layer of complexity to the national dialogue on governance and legal precedents.